in this Tuesday afternoon in the last event for this year's 10th anniversary Employment Network event. The Employment Network event is a week-long job and study fair, as well as networking event that is organized by our institution for the benefit of our students, as well as our colleagues. It is an event that has been inspired and has been organized by Mr. Aurélien Lorange, who is very helpful and very kind to help us also organize and host this event of the ILSA Student Law Journal, the launch of this latest issue in the context and in the framework of this Employment Network event, particularly in order to bring it closer also to our friends and partner universities from all over the world. I would like to extend a particular welcome to Michal Radvan, who is coming to us from Masaryk University in Brno. Michal, thank you very much for joining us today, as well as the students that come and join us thanks to the joys of internet from all over the world, from Japan to Canada, and from Brazil to South Africa, and from Argentina to Mexico and Iceland and Norway. So a warm welcome and a warm thank you to you all for joining us this afternoon. Please note that we do not simply prepare this event as a promotion. This event is also an invitation. It is an invitation to all of you to show you that this is an open journal, and it is very interested in welcoming in the future any submissions on the part of students from our partner universities, because we believe that students have something to say and that it is the right time during their studies to consider taking their first steps into the realm of academic publication. The ILSA Student Law Journal is a student-run, faculty-reviewed law journal. That means that the legwork and all the unpleasant work is undertaken by the students, whereas the faculty have the joy of reviewing all the submissions, submitting comments through a blind review process. It's typically a double blind review process, and then working on these comments together with the authors. The name of the authors and their identity is typically not disclosed to anyone. There is only one person who knows who the author is, and that disclosure takes place at the end when the issue is compiled and we have to work on some very last-minute details. On that note, welcome to this celebration. And for us, also on behalf of my colleague, Ms. Christine Tremblay, lecturer in international law and expert in diversity law, we are here to celebrate today something that is not simply a baptism of students becoming authors. It's also us paying tribute to the courage, the resilience, and the determination of these students to undertake a project that has lasted for more than a year in some cases, and bring it to an end, to a successful end, I might add, in spite of the very, very difficult circumstances imposed upon all of us during this pandemic. So if the difficulty of writing and presenting something in an academic publication exists ordinarily to a scale of 10, because of these circumstances, the difficulty was 100, if not 200. And for that, we would like to salute everyone who has participated in this issue, and we would like to hope that their work can serve as an example for everyone who is listening to us to keep hope, to believe in yourselves, and to understand that, yes, the pandemic is a difficult situation that we are all circumscribed by, but that doesn't mean that without some effort and a little bit of determination and some organization, we cannot take steps forward. It will be more difficult, but it can happen. We have the authors here to prove it. So without further ado, I would like to welcome you one and all. So in the chat, soon you're going to see the link to the first issue of the journal for this year, 2021. The issue is dedicated to international law in practice, and the emphasis is on actual problems that appear before international courts, international tribunals, international organizations of the day, and how these issues have been addressed. We will follow the presentation order as it exists in the table of contents of the journal. Since Ms. Delgado Fitzgerald is unable to join us today, we are going to begin with Max Marold. And then my colleague, Ms. Tremblay, is going to welcome Miriam Hanfeld and David Mustafa, and then I will close again with Ms. Tanvir Rai Singh. And in the end, after the presentations, we will open the floor for Q&A. So please, if you have any burning questions, hold on to them, because we would really like to address them at the end of the presentations, so that we can give the possibility to the speakers to express the content of their work very precisely and hopefully concisely, not more than 10 minutes per person, please. On that note, I would particularly like to say a warm thank you to three people. Eva Maria Foldes, Dr. Eva Maria Foldes, lecturer in EU law, Dr. Cristina Contartese, also lecturer in EU law, and of course, Mr. Aurélien Lorange. The first two, Dr. Foldes, Dr. Contartese, were particularly helpful in the review process of papers regarding EU law that we will hear today. And of course, Mr. Lorange has been the soul behind making this event happen. Now, for 10 years, thousands of students have been able to find early career opportunities, to find internship opportunities, to network and build a career. And for that, he has everyone's, in this program, admiration and respect. Thank you very much. Without further ado now, I would like to call upon Max Marold to present and discuss his article with us. Max, the floor is yours.
Thank you very much, Dr. Vargas. My article, titled The Gambia versus Myanmar, a judgment for judgment's sake, it concerns the still ongoing judgment between the Gambia and Myanmar, that concerns what the court calls application of the Convention on Prohibition and Punishment of the Crime of Genocide. In reality, the judgment is addressing what you may know as, and what the media calls, the Rohingya genocide, which occurred in Myanmar in 2016 and 2017. Now, in short, the Rohingya people are a Muslim minority living in a predominantly Buddhist Myanmar, and now also in Bangladesh. Since 1980s, we can observe a strong polarization between the two religions and a strong us versus them mentality among the people on both sides. And the Rohingya people, as an example, have been denied citizenship many times by the Burmese government and also later on by Myanmar government. And indeed, persecution of the Rohingya people have been lasting for decades and are not something new. Now, we can say that these persecutions, however, reached a certain peak in 2016 when the Myanmar security forces launched a full-scale operation focused directly on persecution of the Rohingya people. The Myanmar security forces, for now still allegedly, began with arbitrary arrests and home displacements in 2016, in October 2016. However, their operations soon spilled over into extrajudicial killings, gang rapes, brutalities against civilians, mass burnings of villages, and so on and so on. Now, however much we want to hide these cruel facts under a blanket of nice and abstract legal language by saying that the judgment concerns interpretations of the Genocide Convention, at the end of the day, we are talking about very real events and with very real victims left behind. And this is what I try to focus on in my article. Now, even though the current judgment between the Gambia and Myanmar is not yet final, we can sort of speculate its development in the future. And at these stages, we can already see a few red flags, all of which I try to address in my article. One that you may have already noticed is the fact that the Gambia is the country suing Myanmar. And we all know that the Gambia is an African country located far away from the atrocities that happened in Myanmar. And I may already tell you a legal principle that says that the damaged party in the court is the one who is going to be awarded compensations for the damages. So at the end of the day, the Gambia will be one afforded compensation for its loss in damages and not the Rohingya people. So I ask myself, is this judgment only for judgment's sake, or will the victims get anything out of it? Yeah. Thank you.
It's my turn, or can I take the floor? Yes?
Yes, of course, but before you do so, I would like to extend a warm welcome to Professor Akinola Akintayo from the University of Lagos in Nigeria. Professor Akintayo, thank you very much for joining us today. Your presence here is a privilege and an honor for us.
Thank you very much, participants. And Michael, thank you very much for inviting me. I'm glad to be here.
Thank you very much.
Yes. Yes. So maybe before I give the floor to our next speaker, in the spirit of the Eurovision, j'aimerais souhaiter la bienvenue aux étudiants, aux professeurs de nos universités partenaires francophones, entre autres l'Université catholique de Lille, l'Université Laval au Québec et l'Université Panthéon-Sorbonne. Without further ado, I would like now to invite the second speaker, Miriam Honfield, who wrote a very inspiring, insightful paper on settlements in the West Bank and its relation with the Rome Statute. Please.
Hello, everyone. Yes, my name is Miriam, and my paper was or is concerned with Israeli settlements in the West Bank and the legal analysis in correlation with that under Article 8-8 of the Rome Statute. So when I started the research for my article, the most difficult part was to find the topic at first. And I had done quite some research into the situation in the Middle East when the prosecutor of the ICC requested a preliminary ruling on the court's territorial jurisdiction in Palestine. And yeah, my interest was very big. And at the time I started writing, the ruling of the pre-trial chamber had not been released yet. So I thought it would be interesting to explore the possible crimes that Israeli officials could actually be tried for if a positive decision would be made. And indeed, the territorial jurisdiction in the Palestinian territory has been confirmed and in the meantime, and this made the legal situation even more interesting. Now, I am sure because of the recent events, the audience is quite aware of the situation, but basically Palestine has been under Israeli occupation ever since 1967, and the Israeli governments over time have established settlements in these areas. And the final research question that I chose was whether or not there were reasons to believe that actions of Israeli officials could amount to the war crime of forcible transfer of population under the Rome Statute. And I structured my paper into 3 chapters, starting with an examination of the historical context of the territorial disputes and the transfer of settlements or of population in Israel and Palestine. And here one of the greatest challenges was actually to get access to key Israeli documents that laid down these settlement policies over time. And then I went on to analyze Article 8-8 of the Rome Statute. And I started with the drafting process and the intentions of the drafters behind the wording of the article. And then I analyzed the different elements of the crime and lastly put them into context with the facts of Israeli practices. And my concluding observations were that indeed evidence of Israeli settlements and practices lead to the assumption that if a case was opened at the ICC, Israeli officials could be prosecuted for the war crime of forcible transfer under the Rome Statute. Yes, thank you.
Thank you, Ms. Anfield. Thank you. I would like now to invite Mr. David Mustafa, who is also one of our students in the student body, but and not least is the editor-in-chief of this year ELSA Law Journal. So please, and he's going to talk about EU leniency policy.
Hi, thank you, Ms. Tremblay. Hello, everyone. It's good to see you here, and also hi to the listeners who are following us on YouTube. I hope you're all doing well. Today, I will talk a bit about my article. It's titulated "The EU Leniency Policy is the Commission being more lenient than it should." So this paper is about the Leniency Policy 2006, which is a tool used by the European Commission to detect economic cartels. I believe everyone should be familiar with the concept of an economic cartel. But if you're not, and you know what a cartel is, you're already in a good start. Basically, a cartel occurs when a group of companies decide to collide together and engage in anti-competitive practices, such as sharing information on prices, increasing prices, reducing output, and so on and so forth. This is a very damaging practice, economically speaking, and it is prohibited as a result. Apart from prohibition, in order to prevent and mitigate these practices, the European Commission created the leniency policy, which is very similar to your regular witness protection program. So, out of the whole cartel group, one of the companies is given a chance to report, and in exchange, the Commission will give it a reduction on the fine or will not give a fine at all. This is a very straightforward strategy. It has been used for a while, and it has been very effective in detecting cartels because the value of the information provided by these insiders is high. It really helps the Commission, and mind you, a cartel can cost up to 15 billion euros to the European Union as a whole, or more precisely, to us, the consumers. So avoiding them is very beneficial to our society. The issue with the leniency policy, however, is that companies can use it as a way to harm their partners or competitors. And the question is, what do we mean by harm? If we take a look at the fines that the Commission puts on cartelists, they can go up to 1 billion euro per company. In Truck's decisions, for example, there were 6 companies participating in a cartel, and the fine they had to pay as a group was 3.8 billion euros in total. The first reporter, however, paid nothing out of that amount. And the most important thing to mention is that this first reporter had participated in the cartel for 20 years. But the Commission simply disregarded that because the evidence was quite valuable. Now, of course, people's first reaction might be, all right, this is nothing new under the sun. Might be a bit unfair, but this is a sacrifice that we as a society are willing to take because in the end of the day, the cartel is brought down, the perpetrators are caught, and the damage is redeemed to society. And that's where we are wrong. You see, in the text of the leniency policy, there is no prohibition on repeating this sort of behavior. And the company can be the first reporter as many times as possible. 3 times, 5 times, and even 9 times, as a very prestigious pharmaceutical company, the name of whom shall not be spoken, has done. And here's what actually happens. These companies, who have a lot of experience in cartel proceedings, can detect all the newcomers in the industry, invite them to join a cartel, and then be the first reporters. The more experience they have with these proceedings, the more they learn on how to provide for valuable evidence. Because the Commission, as you might be aware, has specific thresholds as to what constitutes valuable evidence. And of course, if you are a newcomer to the industry, you will be at a disadvantage in terms of knowledge to someone who has been doing this for 20 years. And I believe this is an anti-competitive strategy and should be outlawed. And by that I mean the Commission should prevent repeat offenders from being the first reporters. And this is not only because these first reporters are learning how to take advantage of this policy, but also because they are being more encouraged to create new cartels, which is contrary to the EU treaties. This is basically what I've discussed in detail in my paper. And you can also find a list of decisions that illustrate how the leniency policy works in reality. I've also provided in detail the reasons why a company can be motivated to report its partners, financially speaking, and also some philosophical aspects, if you will. So I wish you a pleasant read. And of course, if you have any questions, please do not hesitate to contact. Thank you.
Thank you very much, David, for this wonderful introduction to what sounds like a very interesting paper. And last but not least, in closing this very short round of introductions to the different articles published in this issue, I would like to invite Ms. Tanvir Rai Singh to take the floor to talk to us about the EU-Vietnam Investment Protection Agreement, the scope of the agreement, and national treatment. It is a very, very important agreement. I think it's one of the latest in the long string of agreements concluded by the European Union. And Ms. Rai Singh is joining us today in her capacity as a master's student, or you have concluded your master's degree?
I have concluded a master's degree.
We should we should congratulate you also.
Thank you.
That from, I understand, it's Queen Mary's University in London.
Yes, exactly.
So congratulations also on your achievement. Please, the floor is yours.
Yes, thank you. Well, I'm Tanvir Rai Singh. I'm an alumna of The Hague University, and I graduated from Queen Mary University in International Business Law. I'm currently working as a junior customs and compliance consultant in Amsterdam, and I wrote the paper on titled The EU-Vietnam Investment Protection Agreement, Analyzing the Scope of the Agreement and National Treatment. As the title already reveals, I looked into what the scope is and what the standard of national treatment entails. But why is this so important? Well, Vietnam is the second Asian country after Singapore to sign an investment and trade agreement with the EU. And the EU is the fifth largest direct investor in Vietnam, having invested approximately $24 billion by the end of 2018. Negotiations for this agreement lasted from 2012 to 2015, after which the agreement was divided into two parts, the Investment Protection Agreement and the Trade Agreement, which were together signed in June 2019. Due to its scale and impact, it is very important that the agreement has the intended scope and the interpretation of its article is done in a way which is intended by the parties. This is really important for the country in which the investments are being made, the host country, because broad or ill-drafted agreements or articles thereof could potentially result in investment disputes. Therefore, the parties, it is in the interest of the parties to properly define their standards so they can be narrowly interpreted by tribunals, because tribunals have taken very different approaches when interpreting standards. So one way to provide a well-defined and narrow agreement is by limiting to whom the agreement applies to in the first place. By imposing more requirements and narrowly defining its scope, the tribunals have less room to provide an interpretation which is not intended for by the parties. The scope of application, in turn, affects the standard of national treatment, as national treatment compares the national investors and their investments with foreign investors to establish potential violations. Therefore, my paper aimed to critically assess national treatment and the scope, and in doing so, it focused on the clarity of the wording of the agreement, as well as the guidance and the gray areas which the tribunals could have when interpreting those. In the first chapter of the paper, the scope of the investment agreement has been broken down into three parts: the investor, the investments, and the operation of the covered investments. The second chapter looked into the standard, the national treatment. I would like to give a small example of how a word can be differently interpreted by tribunals. For example, in relation to national treatment, there are situations ought to be interpreted. And I know everyone can agree that the likeness of a situation is highly circumstantial. And tribunals have taken different interpretations, a very broad one or a very narrow one, or even one which is in line with the WTO case law. A narrow approach was seen, for example, where the tribunals hold that being in the same line of business or being a litigant in the same case is not enough to establish likeness. And other tribunals, for example, in Occidental case, have looked at domestic producers in general rather than sector-specific investments. So there is a huge difference in how tribunals interpret that. So several aspects in relation to the scope, in relation to the IPA, were well defined and limited the scope, and some were actually broadening the scope, and the same goes for national treatment. Yes, that was my presentation.
Thank you very much, Ms. Rising, for this very interesting presentation. I think that with all that, I would like to thank you all for keeping it short. That was the instruction. They didn't do it accidentally. And since it is an afternoon and probably everybody has worked today, it is important to engage a little bit more with the audience and open the floor up for questions. I think it's only fair if my distinguished colleague, Ms. Tremblay, is the first one to begin. Please, to all students who follow us on YouTube, to all the participants who are present here on WebEx, please don't hesitate to ask your questions. This is what we live for. Thank you.
Thank you. Yes, it's there with me. I was triggered by something which was said by Miriam about one of the challenge that she faced in drafting her paper, which was like finding documents from the Israeli about settlements. And then I wonder, how was it for the three other writers? Did you have also certain challenge in your research? So we can maybe start with Max and then move further.
The challenges in my research were not that much concerning the sources of information. There were plenty of sources out there. The challenge was to accept that, to battle the question of moral superiority, so to say. Me, a European student, a nobody, writing about genocide that, as I said, have real victims, that it's very hard to even talk about, and trying not to seem pretentious when doing so. I really wanted to learn the history of their conflict, which is extensive and it's impossible to learn within 1 year. And then trying to write that down was quite difficult at some points, and especially seeing all the video evidence of those atrocities is not something pleasant to look at. No, definitely not. So that was the biggest struggle, I think, in my opinion.
Thank you. But also so important and that people work on this issue. So we're really thankful. David?
Yes, so the challenge that I had with writing this paper was that I couldn't find any company who was putting this strategy out in the open. So having an internal company strategy to harm their partners. This is not something that you find on the street or in a newspaper. It's very internal. And sometimes the company directors, let's say, who are the people who are drafting everything, they do not put this into an agreement that we will do this and that, and our competitors will be harmed as a result. So I couldn't find this written on paper. I had to look at the data. I had to look at some research papers that indicate this conclusion, and I had to base it on assumption and the law. This was a big challenge, but thankfully the law was very clear. The facts were clear as well. So I believe with some with some effort and of course reading, I had enough evidence to reach this conclusion. It's not entirely based on assumptions, but it's, I believe, something in the middle. And this was the challenge for me.
Thank you. Yeah, well, when you just say the word cartel, for me, like secrecy is the word which come out. So I can, yeah, I can relate to what you're saying about that difficulty. Thank you. Miriam, I don't know if you encounter other challenges in doing your research.
I think it's fair to say, in general, if you talk about, like, I can agree only with Max, when you talk about conflict situations, it's very hard to draw a line and not to how to say this, to attach, but at the same time not be detached from victims and situations. I mean, every day if you read the news, for example, also in Palestine, real people die because of conflicts like this, and we're taking a firm legal point, of course, but we analyze these situations, but it's not easy to forget or to detach from the victims at the heart of the situation. Yeah.
Thank you. And what about you, Tavir? Did you face anything?
Yes, I did actually have some difficulties when I was writing this paper because there are a lot of arbitration cases. And since my paper focused on nitty-gritty and like particular words, it was really difficult to find in like a 200 or 300 page arbitration award an interpretation I was looking for, because it is not part of a conclusion. It's somewhere in the middle when they are actually giving meaning to the words themselves. So it was like I had to read a lot and to find the particular sentence sometimes that I was looking for. So that was really challenging for me.
And all those documents all written in English, or is it like a translation that you're looking at?
Sometimes they were in English, sometimes they were translated, sometimes I had to look for other scholarly articles discussing that particular award, hoping that they will discuss that particular sentence. So it was a whole journey to actually find something.
Thank you. I give you back the floor, Dr. Farias.
I would like to open the floor now to all our distinguished guests, to all our viewers on YouTube. Please, if you have any questions at all, don't hesitate to share them with us. Ms. Yehu, Bianca Maria, do we have some questions perhaps from the YouTube channel that we would like to ask our distinguished colleagues and speakers today?
Not so far. We just have lots of congratulations for everyone for all the papers, though.
That's very, very nice. That's very good to hear. I have some interesting questions and difficult questions for our distinguished authors, because I have had the pleasure of reading all of their papers many times. So I'm going to start perhaps with Ms. Rai Singh first and ask her.
Michael?
Yes, Mr. Professor Akintayo.
Yes, thank you very much. Perhaps I can ask one or two of the presenters some questions or clarifications.
Please do. The floor is yours.
Okay, thank you very much, sir. I must say I find all the papers very, very interesting. Wonderful presentations. Miriam, I'm particularly interested in your paper because it's actually very topical. So, but I want to ask, in your interrogation of the conflicts between the Palestinians and Israelis and the potential charges under international criminal law that officials of Israelis could be open to or exposed to under international law, did you examine possible defenses or justification, or at least what the states or the Israeli states the policies, what they're saying with regard to these acts of terrorism, violation of ICC that you have identified?
Thank you very much for your question. So as I said, it was very difficult. First of all, because of the language barrier, I don't speak Hebrew, and yeah, these documents were drafted in Hebrew, but also access is very difficult because yeah, these are government documents, and at least with my research, I could not really find something, but what I relied on were several UN studies and researches from independent commentators and observers. And basically what I found was that ever since the war, the Six-Day War in 1967, when Israel occupied even more Palestinian territory, the settlement policy began, and ever since then, a UN study found that every Israeli government has left office with actually more settlements in the occupied territory than the previous one. So it was quite interesting from a legal point of view to see how the situation evolved over the years without yeah, any interference. I mean, of course, there were lots of condemning yeah, comments from representatives at the UN and so on. But as we see today, the conflict is still hot, and the practice continues. I mean, the reason why this got so heated again now was because of the yeah, how to say, removing of Palestinian people living in a village, and yeah, Israeli authorities claiming that yeah, the land, and these people having to leave. And yeah, what at least what my research gave me was that these practices are contrary to Article 8 to be 8 of the Rome Statute. So it was or it is illegal transfer of population. But Israel is not party to the ICC. That is very important, and therefore it is, yeah, an interesting read maybe, but for now only theory. So, yeah.
All right. Thank you very much for your response. That's quite interesting. Max, cartel, lenient policy, that's really very, very interesting, and that's quite an insightful paper you have there, and especially for us from this part of the world. That is one example of best practice that our region could definitely borrow from the European Union. But you have identified the benefits.
Professor Akintayo, you probably mean David. Is that about the paper concerning the EU leniency policy?
Exactly.
Yes. So your question is for David Mustafa. Thank you.
Okay. So sorry. Can see Marcos in his anyway. So David, is it okay, David? So you have identified the benefits of the policy, but also the potential harm that could result therefrom. I'll be very interested in your recommendations as to how to navigate that very serious lacuna or conflict, so to say, the benefits on the one hand and then the potential harm on the other. What's your recommendation as to how to surmount that particular problem? Because you agree with me, like you have said, that it is quite beneficial to the society and also potentially harmful. What's your recommendation going forward?
Yes, thank you for your question, Dr. Akintayo, and of course, pleasure to make your acquaintance, virtually, of course. So basically, yeah, it's you pointed it very rightly. So it's very damaging to have these cartels, and I would like to point out that in the article, if you can see, you will see tremendous amount of euros being lost to these practices, and this damage, of course, is passed to the consumer in the end of the day. Which, happy or not, it's the reality. I have to give credit, though, to the European Commission, because this leniency policy has actually been effective. I mean, it's sort of a sacrifice, but at the end of the day, some cartels are caught, and it's better with some rather than none. So far, we can say that in broad terms, this policy has been effective. It's just that any company who can see the gap, if they have a good lawyer, of course, which I'm sure they do, can actually use it to their advantage. Sorry for that. So my suggestion for that, and I believe you can also see it in the article, is to first of all start by preventing these repeat offenders to be the first reporters. So the European Commission, when the applicants arrive, they give them a sort of list of conditions that they have to fulfill in order to be the first reporters. So the amount of time that they spend in the cartel, the kind of evidence that they are providing, these are all conditions that the European Commission puts in front of the company before accepting it as a first reporter. Now, my suggestion is that among these conditions, the European Commission puts not being a repeat offender as a core condition, first of all. And the second of all, this year I took a minor in compliance. I had the pleasure to learn a bit about the world of compliance and how things can be, how beneficial can be for a company to have an internal policy which really condemns this type of actions, harming competition, forming trusts, and engaging into corruptions. So I believe that needs to be part of the internal policy of the company as well. So among all these texts of articles of association that the company has, which says, oh, we shall not engage into corruption, we shall not fund, let's say, child labor or slavery in other states, it's good to add this as a part of their internal policy, not harming competitors. Simple as that. Of course, this is a bit theoretical right now. Maybe it's a bit too ambitious, but first step needs to be taken. And once a company manages to take this first step, then I believe it would have a domino effect, and other companies, of course, will try to follow. That's what I think, of course. But yeah, thanks.
Yeah, thank you very much, David. That's quite interesting. But I just want some more information here. Is there the proceedings and the sanctions that is attached to the violation of this policy? Is it only civil, as in paying fines, damages, and the rest of them, or do they also invoke criminal proceedings against violators?
Right now, this remains as administrative punishment. So the commission will only fine the company. In the US, I believe it's different. They also go after the directors themselves. So if they see a director who has willingly participated in this form of anti-competitive practice, they will also fine the director or go after him, let's say, in criminal proceedings. But in Europe, it's only administrative. Yeah.
Okay, great. Thank you very much.
Yeah,
Michael, I think
Yes,
I'm done.
Professor Aguinaldo. Thank you very much. Thank you for these questions. In the meantime, we have also had some questions trickling in from from our audience, from people who hear your presentations from all over the world. So let's see what are some of the most interesting questions that we have received. Well, basically, I will ask you all the questions. They are general questions for all the authors. The first question is, how did you decide what to write about? And I would like to start here by Tanvir, Ms. Rising. So, Tanvir, how did you decide what to write about? What is it that made you choose this particular topic?
Well, during my master's, I took an advanced course in investment law. And during the course, we were given an assignment to prepare for a lecture just briefly about what are different approaches taken. And we were also taught that tribunals take different approaches in different cases. So I thought, what about an EU agreement? What happens to that? How does a tribunal interpret that? So that's why I came on this idea to actually look into the EU-Vietnam Investment Protection Agreement and to look at 2 articles to assess what their words actually mean and how it can be interpreted.
Thank you very much. What about you, David? What is it that piqued your interest?
So basically, I decided to choose this topic. The motivation behind this topic, I actually found it on the last year's second year course, competition law. I believe, we were having a discussion in class, Ms. Stukovic, and she was explaining the leniency policy, and I was going through it, and I saw the gap, and I immediately had the question, like, why is the gap over there? Is it actually being used by these companies? And the answer was yes. Companies can use that. It's common, and they haven't prohibited it as a strategy. So I was like, I need to write about this, and that's how it started.
Miriam, on to you.
Yes, as I said, I did a lot of research into the situation. About a year and a half ago, when the prosecutor's request for a ruling on territorial jurisdiction in the situation in Palestine was released, and I read through the amici curiae briefs and did some background research as well. I think everyone is aware of the situation in Palestine, but since I study law, it's much more interesting to look at it from a legal point of view. And it's easy to say that crimes are being committed, but to actually look into what is the crime and who is responsible for this and what actually happened, and to put this in a frame, it was very interesting to me. And I had several topics that were that I took into consideration, but this one was the one that I think I was most passionate about, or somehow felt the need to say something about, like David said. And then I picked this.
Thank you, Miriam. And Max?
However weird this might sound, I've been interested in genocide for the past 2 years, both from the legal perspective and from psychological one. And at the beginning, I wanted to write about the Rohingya genocide and the role that Facebook played in it. However, pretty soon I learned that this would take a full book to discuss and not just an article. And then in January 2020, the order came out of the ICJ for this judgment. And I took the opportunity to write a commentary on that. Yes.
Thank you very, very much. Now, another question, and perhaps here we can have one or two of you address this. Do you have any do's and don'ts for people who would like to get into academic writing? So it seems that your work has inspired quite a few others to give it a go. We also have a next issue coming out, and for the next issue we will welcome submissions due on the 15th of September, but that we are saving as an announcement for later. But in the meantime, are there any do's and don'ts from your experience so far, having undertaken this work for the last 1 year or so, that you would like to share with the audience when it comes to doing research and writing for that? Yes, Miriam.
Yes, just a very basic one. So when I pick my topic, I have a great political interest in general, but what I was advised a lot was when you write a legal paper, to not let your political opinions or other things interfere with that. So if you pick a topic and I don't know, you want to write about it, then it has to be a legal question and not like a personal one or a political one.
Thank you very much. Anyone else who would like to contribute? Yes, Ms. Rai Singh.
Something that has helped me a lot is really sticking to the IRAC structure, the issue, rule, application, conclusion. It has always helped me, and even in the big IRAC, I made mini IRAC, so I could actually not lose like my thoughts, because sometimes there's so much information that sometimes you just get lost. So really sticking to the IRAC structure and never leaving footnotes till the end.
Yes, I think that the older you grow, the more challenged you become by footnotes and referencing. And then you discover that there are programs that exist out there that can do it for you if you program them properly. And then different journals have different citation styles, so you have to do it over and over again. Thank you very much for this. Another question that we have is, would you like to continue doing work and research in the fields that you wrote about?
I would say, yes, I would say most definitely, and especially focusing in on the role that Facebook played on my topic. But yes, more on that maybe next time.
Anyone else?
Yeah. And yeah, for me, I would say, yeah, I would be interested in writing in this topic, maybe in a distant future. I think that first I need to consult a lot of practitioners and academics in order to have a more insider view. Right now, I've simply made my research. Of course, Westlaw. I think everyone is familiar with that. But it's my research is still fresh from the books. So I believe this is an interesting topic. Of course, I wouldn't want to get in conflict with any of the companies that participate in such cartels. I don't plan to apply for a job to any of them, but in the end of the day, I don't want to remain jobless. But yeah, I think in the future I could pursue this. It just I need to do it on a different level. But yeah.
Thank you very much. Ms. Rai Singh and Ms. Hanfeld, would you like to add something to that? If not,
Well, I actually am doing some research. I have another publication I got published last summer on investment law as well, thanks to a professor from Queen Mary University, Dr. Rafael Leal Arcas. Thank you. He has actually helped me, and I'm currently working on hopefully, which will be another publication soon. So I am actively pursuing that.
thank you very much. Thank you. Miriam, anything from you on this point?
Yes, I'm also still interested in the topic. I mean, it's much bigger than 10,000 words or something like this. I mean, books have been written on this, and I think it's quite interesting to observe how conflicts and situations evolve, especially now that it's in front of the International Criminal Court. It will be quite interesting to follow the proceedings and responses and how the situation evolves. So I'm definitely still interested. Yeah.
Okay, thank you very much. We have a very interesting question addressed to all the authors. And the question is this. You started writing about your paper and you saw the topic under a certain light. Then you researched, you wrote it, and the question is, do you see your topic now, after having gone through this process, in a different light compared to how you saw it before you started or when you started writing? Has something changed in the way that you're thinking about this topic after having gone through this process of research and writing?
Okay. So I would say that yes, absolutely. Especially because of the COVID times, they brought a lot of change into thinking about things. And what it did for the one, it made it more real. the entire event as it occurred. It wasn't just a distant thing that we were studying in one subject, but you were actually there reading everything about it. And yeah, I think that's about it. It made it more real for me. Yeah.
Thank you, Max. What about the rest? Any comments on this? Did it change your perspective a little bit on the topic, reading and writing about it?
For me, it really changed the way I look at international or even like simple agreements, because every time I see a particular word, I'm like, why is that word chosen, not this one? Or how could this be interpreted by a court or a tribunal? Why is this written in this way and not that way? So it really opened my mind into being more specific, perhaps.
That is a big achievement. Congratulations. You would be surprised, but sometimes when judgments are drafted, blood is spilled over a single word. When agreements are negotiated, sometimes they are deadlocked on one sentence in one paragraph. That is the most important. So what about you, David, Miriam? Has something changed in the way that you see your topics now that this piece has been published, and perhaps we can expect something more of you on this topic in the future?
Yeah, I think I can agree with the previous two that it definitely changed. I mean, as I said, you have this broad knowledge, you're interested in something, and then you start your research, and suddenly you get more and more information, and you broaden your knowledge. I mean, I'm far from a specialist about conflicts in the Middle East, but yeah, the things you research and read and the way you conduct your research definitely change the way you see the topic. Yeah.
Yeah, and for me, I have to say, I've grown a lot since the day when I started this paper and when I finished. But to be honest with you, I haven't changed my opinion. I was presented with a conclusion in the beginning, and my endeavor was only to make that conclusion more visible. I wasn't trying to find why. I just want to explain how that is achieved. So in that sense, I don't have much of a much of a change of mind in regards to the topic. I just believe I have acquired more information, and I can present it in a clearer way. But in that sense, not a lot has changed. But that was a very interesting question, by the way.
It's nice to confirm yourself through your research. It makes one feel that one is very intelligent. But there are a couple of more questions. I will try to be brief about it. One question is about enforcement of international criminal law. And the question is, your main criticisms when it comes to the enforcement of international criminal law. What are they? And do you think anything will change when it comes to victim remedies and or reparation? So it seems that there is a lot of emphasis in getting the bad guys, but perhaps we should put a little bit more emphasis on providing remedies to the victims or reparation. Do you have any thoughts that you can share with us? Particularly, I think this question is for Miriam and Max, perhaps. Who would like to go first? You have no option, you have to go, but one of you will go first.
So the question again is what?
So the question is, do you have any criticism when it comes to the enforcement of international criminal law? For example, genocide, the prohibition of genocide, is it enforced? And do you think that anything will change in order to make reparations for victims and remedies for victims better or more effective or efficient? Do you believe in your case that the judgment issued by the International Court of Justice or the proceedings before the International Court of Justice will make a difference to the lives of the victims, the millions of Rohingya who have been displaced and subjected to horrific treatment?
Okay, so when it comes to enforcement of international criminal law, this might sound pessimistic, but I would say that it's currently the best that it could be, and I'm surprised that it's that good. What we need to understand is that there are a lot of ancient principles in play, for example, sovereignty, which are really hard to just dispute and set aside for certain crimes. But for real-world consequences, for specifically this judgment, I don't think it will have any consequences, any positive impact on the victims, if any impact at all. However, I hope that through this judgment, more law will be developed that will, in the future, have the potential to help victims of genocide. I hope for that, at least.
Thank you very much. What about you, Miriam? We have unfortunately seen in the news that the settlements in East Jerusalem, the West Bank, have proven to be a constant powder keg for not only for the Middle East, but for the entire world. Is there any room there for the enforcement of international criminal law, for remedies for victims, and for reparation?
Yeah, I think Max put it quite well. As much as some people try or want to, no one can force Israel to become a state party to the ICC, and that will not change. And that is a given fact. I mean, the situation is that tense, that even though the prosecutor asked a preliminary question, dozens of people and states, institutions, organizations responded to this, even though it was a preliminary question, no initiation of investigation, not even a case before the court, but still the situation is that hot, and Israel is not a party, as I said, and as it looks now, it will not become one. So the enforcement question, is a question, but it doesn't look like it's going to lead anywhere soon regarding this conflict. And for victims, this means if there is no case, there will be no solution for them. There will be no benefits for them, and that is the situation. So at the moment, there is no enforcement, at least from the ICC, regarding this conflict.
Thank you very much for this very realistic approach. I hope that you will both be wrong and that it will make a definite and direct impact on the lives of victims. Another question for Ms. Rai Singh, it's about a combination of taxation and the agreement between Vietnam and the European Union. And the question is a little bit more general for you. Do you believe, because I understand that there is a discrepancy between salaries and taxation of people working in Vietnam and salaries and taxation of people working in the European Union. Don't you believe that unless there is harmonization between the taxation rates on certain products between the European Union and Vietnam, that there is a risk that the European Union is getting itself into trouble by concluding an agreement with Vietnam, a country that is considerably cheaper than the European Union? So presumably the idea would be, wouldn't it be necessary to first, before we conclude such agreements, have a common understanding on what would be the applicable tax rates for goods and services between the European Union and Vietnam, and then proceed to open up the market for further investments? Perhaps something like this has already happened and we're not aware of it. But shouldn't we first, particularly in the age of the internet, shouldn't we try to subscribe to universal standards of taxation first before we try to open up our market to countries such as Singapore or such as Vietnam, or perhaps even tomorrow India or China?
To be really honest, I am not really specialized in taxation when it comes to investment agreements. I've always focused more on the arbitration side. So I would not want to make a judgment about that. But I do think, more generally speaking, that the EU does have a lot of negotiating power. And sometimes it's perhaps not, I wouldn't say fair, but it's not a negotiation where both parties are equally strong. So that is something that I would want to point out. This can also be seen, for example, in other agreements of the EU where they deal with opening up particular markets that countries which they make agreements with open up more markets than the EU actually opens, but I cannot really speak as to taxation. My apologies for that.
We have a very interesting contribution by Professor Advan, who indicates that tax issues are regulated by agreements on double taxation, if I read it correctly. Yes, so perhaps this is a matter separate to the bilateral investment treaty. So on that note, I don't think that I have any further questions in the chat that I can ask you, but I would like to open up the floor once again if any one of our distinguished colleagues and guests would like to ask any further questions. And if there are no such further questions, then perhaps one last time to Ms. Tremblay before we close this beautiful event.
I don't have any specific question. I just want to say that I'm really proud of our students and what they have accomplished. And I get really inspired when I read their papers and when I see them standing so strong and presenting. Wow. You had told me it would be a great event, but I'm really flabbergasted. So congratulations.
Okay, and on that wonderful note, I would like to close this session. I would like to express our warmest thank you to everyone who participates here, to our students, to our audience on YouTube, to all our distinguished guests who are here with us today. And of course, I would like to reiterate our wonderful invitation to all of you who hear us, and to your friends, and to your colleagues, and to your classmates. Please, if you are so inclined and if you are so inspired, discuss with your professors, take a look a little bit at the drafting requirements for the ILSA Law Journal, the instruction to authors sheet, so that you can see the wonderful criteria that we have there, 10,000 words spacing, footnotes and the like. And please do consider submitting a paper for publication with the ILSA Law Journal. The deadline for the next issue is the 15th of September. Once you submit your paper, your name will be removed. Then for this year is the last year for myself and Ms. Tremblay, and we're not doing it again. We have already done it quite a few times, so this is the end of the road for us. And we will then read it. We will give you some comments. Go, no go moment will come at some point. And the ambition is to be able to close this volume by Christmas. So after you submit, we will be moving a little bit faster than on this issue. So please be prepared for it. We think it is a wonderful opportunity to take your first step in academic publication, to shoulder the responsibility that this assumes, to take part in a global conversation, and ultimately to be proud of something that comes from you as a gift to the world. Because in the realm of publications, unless you end up writing a very, very popular textbook, you don't write to get rich. You write because you have something important that you need to share with the world. And on that note, thank you all very, very much, and have a wonderful evening. Good night.
Thank you.
Thank you very much.
Thank you.
Thank